In the state of Florida, law dictates there is a difference between normal wear and tear and damage to a property. There is, however, no legal definition of either one, so we have to rely on industry standards. For starters, every property requires a certain amount of maintenance, whether there is a homeowner living there or a tenant. Some properties require more maintenance and repairs than others, and that could just be simply due to age or the type of property, or even lack of proper maintenance. This is considered normal wear and tear of a property. Every item inside a home has a certain lifespan before it needs to be replaced. For example, the carpet can have a lifespan of approximately 5 years, the interior paint say 3 to 5 years, the air conditioning system could be 10 to 15 years, the appliances 10 years, etc. So when you own an investment property, keep in mind that it will need maintenance, and that is not usually the tenant's responsibility. Not only is that a fact, it's the law. The idea here is that just because you are renting a property, you cannot forget that there will be required maintenance needed from time to time. So make sure you budget for this. Consider this also. A tenant with, say, a husband and wife and 3 children will realistically cause more wear and tear to a property than a single person. But you cannot discriminate against the family because they cause more wear and tear on your property because there's more people there, to say that they actually caused real damage. Simply because a larger family may have caused more wear on the property, the flooring and the walls, you just need to take this into consideration when assessing wear and tear and actual damage at the time of move out. And just consider more wear and tear, not as actual damage. Now let's talk about damages. This term means tenant caused damage to a property, but again there is no legal definition. In our industry this is regarded as excessive wear, intentional or unintentional damage caused by a tenant or their guests to the property. So damage can be large stains on the carpet, excessive scuff marks or dirt throughout all the walls. It could be punch holes in walls, broken fixtures, etc. It's a good idea to have an idea of what would be considered normal wear and tear and tenant caused damage ahead of time, especially when processing a security deposit claim. This can be difficult because not only do you have to differentiate between the two, but you also have to consider the depreciated cost of items. Let's say damage is caused to an item such as carpet, causing it to be replaced for re-rental. If the carpet was already 3 years old when the tenant moved in, you cannot simply charge the tenant for the full cost of replacement. That would be considered unfair and illegal by most judges. A depreciated or prorated cost needs to be calculated so that a fair claim can be made against the tenant's security deposit. If a carpet were to normally last, say, approximately 5 years and the tenant moved out at the 3-year mark but left the carpet in disgusting condition throughout, then 3 divided by 5 means that the tenant moved out when the carpet was around 60% of a way through its lifespan. Therefore, the tenant should be charged for the remaining 40% of its lifespan. That is 40% of the actual cost of replacing it with a like-kind brand new carpet. We have a list of approximate lifespans for properties and items to help you with these damage cost calculations. Go to www.wemanageorlando.com for more information.